A shareholder, also known as a stockholder, is a person who holds at least one share in a company. They're not the same as a stakeholder though. This is someone who has an interest but doesn't necessarily hold shares. Being a shareholder confers certain rights and responsibilities such as voting rights and the right to receive dividends if the company makes a profit. Shareholders are owners of the company, technically part owners if there's more than one, but they aren't always involved in the day-to-day running of the business. That duty is left to the directors and company management. However, company directors can also be shareholders. If a shareholder has more than 50% of stock, they're a majority shareholder. If it's less than that, they're a minority shareholder. How shares are issued. Shares are issued during company formation, but issuing further shares is an effective way to raise finance, particularly for a fledgling business with no credit history which would struggle to get a bank loan. If your company is limited, i.e. limited by shares, then legally it must have at least one shareholder. There is no upper limit on the number of stockholders you can have. When you register your limited company with Companies House, you need to provide financial details about the shares and who owns them. Share capital, this is the number of shares you issue, the total number and their total value. For example, if you have 100 company shares worth £1 each, your total share capital is £100. Public limited companies, PLC, have a minimum share capital of £50,000. Shareholder information, you must supply their names and addresses. Share information, you must tell Companies House the type of share allocated, and the rights conferred. A shareholder, stockholder, of corporate stock refers to an individual or legal entity, such as another corporation, a body politic, a trust or partnership, that is registered by the corporation as the legal owner of shares of the share capital of a public or private corporation. Shareholders may be referred to as members of a corporation. A person or legal entity becomes a shareholder in a corporation when their name and other details are entered in the corporation's register of shareholders or members, and unless required by law, the corporation is not required or permitted to inquire as to the beneficial ownership of the shares. A corporation generally cannot own shares of itself. The influence of shareholders on the business is determined by the shareholding percentage owned. Shareholders of corporations are legally separate from the corporation itself. They are generally not liable for the corporation's debts, and the shareholders' liability for company debts is said to be limited to the unpaid share price unless a shareholder has offered guarantees. The corporation is not required to record the beneficial ownership of a shareholding, only the owner as recorded on the register. When more than one person is on the record as owners of a shareholding, the first one on the record is taken to control the shareholding, and all correspondence and communication by the company will be with that person. Shareholders may have acquired their shares in the primary market by subscribing to the IPOs and thus provided capital to the corporation. However, most shareholders acquire shares in the secondary market and provided no capital directly to the corporation. Shareholders may be granted special privileges depending on the particular share class that they hold. The board of directors of a corporation generally governs a corporation for the benefit of shareholders. Shareholders are considered by some to be a subset of stakeholders, which may include anyone who has a direct or indirect interest in the business entity. For example, employees, suppliers, customers, the community, etc., are typically considered stakeholders because they contribute value or are impacted by the corporation. Types. Beneficial shareholders. A beneficial shareholder is the person or legal entity that has the economic benefit of ownership of the shares. Nominee shareholders. A nominee shareholder is the person or entity that is on the corporation's register of members as the owner while being in reality that person acts for the benefit or at the direction of the beneficial owner, whether disclosed or not. A nominee shareholder relationship in most jurisdictions is governed by trust law, and therefore is simple and passive. Generally, the nominee is not required to do anything except carry out specific, lawful, actions if so directed by the beneficiaries. In the event a nominee becomes insolvent, the beneficial shareholder should not be affected as the nominee's creditors cannot take possession of the trust assets. In some Asian jurisdictions, nominee shareholding is achieved through contract law and is very complex and risky. For example, in China under the Supreme Court rules, using a nominee shareholder is ineffective in preventing debt collection actions, as a nominee shareholder cannot escape liability for this on the grounds that they are not the beneficial owner. If a capital call is made and the beneficial owner omits to provide additional funding, the nominee shareholder is liable to fund the capital call using their own funds. Finally, shares held by a nominee shareholder can be inherited or subject to marital property division. Ordinary shareholders. An individual or legal entity that owns ordinary shares of a company, in the United States commonly referred as common stock, is usually referred to as an ordinary shareholder. This type of shareholding is generally the most common. Ordinary shareholders have the right to influence decisions concerning the company by participating at general meetings of the company and in the election of directors and can file class action lawsuits, when warranted. Preference shareholders. Preference shareholders are owners of preference shares, in the United States commonly referred as preferred stock. They are paid a fixed rate of dividend, which is paid in priority to the dividend to be paid to the ordinary shareholders. Preference shareholders usually do not have voting rights in the company. Rights. Subject to the applicable laws, the rules of the corporation and any shareholders' agreement, shareholders may have the right to sell their shares, to vote on the directors nominated by the board of directors, to nominate directors, although this is very difficult in practice because of minority protections, and propose shareholder resolutions, to vote on mergers and changes to the corporate charter, to dividends if they are declared, to access certain information. For publicly traded companies, this information is normally publicly available, to sue the company for violation of fiduciary duty, to purchase new shares issued by the company, to vote on and file shareholder resolutions, to vote on management compensation, say on pay, to vote on management proposals, to what assets remain after a liquidation. The above-mentioned rights can be generally classified into 1. Cash flow rights and 2. Voting rights. While the value of shares is mainly driven by the cash flow rights that they carry, cash is king, voting rights can also be valuable. The value of shareholders' cash flow rights can be computed by discounting future free cash flows. The value of shareholders' voting rights can be computed by 4 methods. The difference between voting shares and non-voting shares, dual class approach. The difference between the price paid in a block trade transaction and the subsequent price paid in a smaller transaction on exchanges, block trade approach. The implied voting value obtained from option prices. The excess lending fee over voting events. While many businesses are wholly owned by their company founders, others have a diverse ownership structure comprising multiple shareholders who possess a financial stake in the company's future. Does being a shareholder grant them any authority over the company's daily operations? To answer this, we need to first understand the distinctly different roles of shareholders and directors within a company. Shareholders and directors. Shareholders own the company by buying and holding its shares, acting as the company's financial supporters. Directors are responsible for day-to-day management of the business and its operations. Being a shareholder does not automatically confer the right to have a say in how that company is run on a day-to-day basis. Unless specified in the Articles of Association, a director is not required to be a shareholder, and a shareholder has no automatic right to be a director. Although there's no automatic right, there is nothing preventing directors from also being shareholders. As company founders tend to become directors and may have begun as the only or the majority shareholder, this is not uncommon, especially in small and medium-sized companies. This dual role often blurs the distinction between shareholders and directors, particularly in family-owned businesses or where founders continue to be actively involved after retirement. Shareholders may therefore have a lot of influence over directors or act as de facto directors, even if they retire but continue to take an active role in the company's affairs. In this instance they must tread carefully, as they may still be legally considered directors in the event something in the company is mismanaged. What responsibilities do directors have? The title director is given to senior management staff in a business. Usually, the chief executive officer, CEO, chief financial officer, CFO, and chief operating officer, COO, report to the board of directors. Directors are legally responsible for the company's management. Directors' duties include ensuring timely and accurate information submission to company's house, striving for the company's success, and acting in its best interests. Failure to meet these responsibilities can lead to investigation and disqualification. What rights do shareholders have? Depending on the size and nature of a company, a shareholder's access to company information and involvement in daily operations may be limited. They do not always have access to most company records, which are managed by directors. Beyond receiving annual accounts, additional information is available only if voluntarily provided by directors. Nevertheless, shareholders have specific rights and duties outlined in the Companies Act 2006, the company's Articles of Association, and any shareholders' agreements. What company decisions do shareholders have a say in? While directors are more involved with the daily business operations, depending on the voting rights attached to their shares, shareholders can hold significant sway over major company decisions at shareholders' meetings. Major shareholders possess considerable voting power, which can sometimes result in a controlling interest, where one individual can outvote all others. Generally, shareholders have the right to vote on key decisions such as appointing or removing directors. Majority shareholders can appoint or remove directors at any time. Amending the company's Articles of Association. Changing the company name. Approving long-term service contracts for directors, and authorizing large transactions, such as the acquisition of another company. While major shareholders have substantial influence, minority shareholders typically have less sway over the company's direction. However, it is broadly accepted in the business world that granting shareholders excessive power over daily operations can hinder directors and disrupt the business's functioning. Can shareholders tell directors what to do? While shareholders have significant influence through their voting rights as well as the ability to approve major decisions, they do not have the authority to directly instruct directors on how to manage the company on a day-to-day basis. The directors have the autonomy to manage the company's affairs within the framework set by the shareholders and the company's Articles of Association. Thank you for watching this video.